friends, welcome to the platform of Darshanik. So guys, on this platform of Darshanik IS, today I'm going to discuss with you one of the concept from ethics paper. So in your ethics paper, there is a topics that is ethics, morality and branches of ethical reasoning or essence of ethics. So in that, there are a lot of concepts that UPSC ask, especially keyword based concepts or value loaded terminology based concepts. So in this lecture, I'm going to discuss with you one such a concept from ethics paper that you should know, especially from administrative ethics paper that you should know, that is letter of the law and the spirit of the law. Okay, so this concept is very unique and you can use this concept at multiple locations in your answer writing of ethics paper, even in your polity paper answers. And also you can use this concept even in your case study solution part. Okay, so what this concept, letter of the law and spirit of the law. So this is very debatable issue, that whether we should stand by the letter of the law or we should stand by the spirit of the law, and which one is more important, what are advantages, disadvantages, and what should be the conclusive argument of this debate, that we will try to discuss. So by the heading itself, title itself, you must be understanding that letter of the law means following the literal interpretation of the law. Okay, while spirit of the law, which focuses more on essence, that why we created the law, what was the purpose of the provision. So, and if you confuse between the letter of the law, spirit of the law, a lot of mismanagement, misgovernance can happen, illegal things can get justified, or even unconstitutional things can happen, or rather actions we take under letter of the law might end up creating actually a bad situation for the society, etc. So what is the letter of the law and spirit of the law? It's a very debatable issue. So just to give you an example of Farm Bill. So when Farm Bill was brought by the Parliament, it was brought through ordinance. Now why ordinance is there in the Constitution? Okay, so letter of the ordinance, that what is the procedure to pass a ordinance, legal procedure, mostly it was followed. But what is the essence? Why ordinance making power is there in the Constitution? So ordinance making power spirit, okay, is to deal with emergency situations. So only when in emergency situations, okay, like disaster management, war, etc., it won't be possible to convene the parliament's meeting, and in that such a case, executive can pass or make some laws using ordinance as a way out. So ordinance was introduced to deal with emergency situation, okay, but you use that provisions, okay, to make any normal laws like Farm Bill, etc., and obviously it is immoral or unethical and can create even a bad situations in your country, and all the protests that started after Farm Bill is a reflection of that. And that's why letter of the law and spirit of the law is very important debate. It's very significant debate in your ethics paper. And that's why while doing anything, while performing any task, we have to take into account not just letter of the law, but also spirit of the law. Now let me give you, tell you one more example. You must have heard about many lawyers in India who defend the criminals. Like Ram Jetmalani was one such a lawyer. Largely, his clients were Harshad Mehta, Ketan Parekh, or even those who murdered Indira Gandhi, those who murdered Rajiv Gandhi. He was client of, those were his clients. Even he defended Asaram Bapu. So, if we judge the action of any lawyer based on whether the client that he is representing, especially criminal clients, can we call it to be correct? Because every lawyer will say that he is defending his client and he is doing his duty, okay, and he is following the letter of the law, that every lawyer should try to protect and defend his client. But then I told you there is a difference between letter of the law and the spirit of the law, okay, and so we need to focus more on spirit of the law compared to letter of the law. Why? So when Gandhi became the barrister, when he joined or came to Rajkot, okay, and he was fine, he got the one first case, and in that case his client, okay, was accused of a theft, robbery, etc. And Gandhi was fighting his case. 5-6 months Gandhi fought his case very sincerely, but after 5-6 months Gandhi realized that his client was lying and he has actually stolen the things. So when Gandhi realized that, okay, Gandhi clearly refused to protect this criminal client. Okay, Gandhi asked him to go and confess before the court, and he explained to him that he will try to reduce his sentence, or Gandhi clearly refused to take his case. And so when client didn't agree, the next day Gandhi went to a court and rested his case from his side. He gave up that case. So Gandhi here had showed us, okay, indirectly that why we need to focus more on spirit of the law, not the letter of the law, because it's a duty of every lawyer to protect the clients. But every lawyer, if start to protect his criminal clients, and criminals started to get justice instead of victims started to get justice, then people will no more have any faith in the judicial systems. Okay, Ram Jethmalani in one case defended Muttu Sharma, who murdered Jessica Lal in the pub in front of hundreds of people. And in district court, he used all his talent, knowledge, everything, okay, to get Muttu Sharma not guilty even after committing murder in a pub, in a public place. Now, whether then, like Ram Jethmalani kind of lawyer or any other lawyer who defends his criminal client, okay, then he is following letter of the law. But every lawyer start to do that, use his talent to ensure that even after doing a crime, you will get out of the justice system, you can escape the justice system. Then there won't be people trusting the police, trusting the justice system, and there won't be justice system required. People will start doing justice on the street, and then there won't be requirement of any lawyers, or we won't be needing any more justice system in the first place. And that's why letter of the law might be that lawyer should defend the clients, but the spirit of the law, okay, is that one should protect the justice system, one would uphold the justice system, one should uphold the essence of justice, that criminal should get punished and client or victim should get the justice. And so, yes, it's a duty of a lawyer to protect the client, but that doesn't mean get him out of the jail, but rather you can plead guilty, get him reduced sentenced, confess his crime, save the time of a court, and try to settle the matter, okay, by asking him a lenient punishments. But if you don't ask for lenient punishments, okay, and try to protect the clients, then it will impact the entire justice system. And so one should largely focus on spirit of the law, not the letter of the law. Let's take one more example. If you are an attorney, okay, and you have some client, an old person, he has written a will that he wants to donate his money to a charity. There is an orphanage where 1,000 students live, and he wants his 100 crore rupees wealth to be donated to that orphanage, and 1,000 of orphan kids, okay, their life will get improved. But let's say suddenly, okay, one day he has a change of mind, change of mood, and he decided that now I don't want to give my 100 crore to orphanage, I want to give 100 crores to I want to buy some IPL cricket team in my name on my behalf. And he asks you to make the will, a new modified will, where his 100 crore money will be used to buy a IPL team after his death. Now, once that happens, okay, he next day you bring the another will, he signs the will and he dies. Now you have two wills. One will says that money should be donated to the orphanage, to the charity. Another will says money, with the money, buy the IPL team. And you are the only attorney who knows the existence of two wills. You can clear one will, only keep one will, execute that will. And none of his relative, any friend, anyone knows about the existence of the second will. No one will be holding you legally accountable, etc. So in that case, what you will do? Mostly people will say, I will donate my money to the charity, 1000 बच्चों का भला होगा, etc. And you can tear the second will, okay. But point here is, okay, you should not be tearing the second will. As an attorney, it's your duty is not to see how much benefit will come out of execution of will. कि charity को पैसा देके ज़्यादा फायदा है compared to buying IPL match. But that's not your decision, that's not your money. And so your decision, your priority should be, as a lawyer or as attorney, is to execute the most recent will. And why you want to do that? And by executing most recent will, rather there will be more pain will get created. 1,000 kids in orphanage will not get the money, their life will get impacted. But the point is, okay, every attorney, if started to execute the wills as per his own whims, as per his own calculation, as per his own mentality, then automatically that will be very problematic thing, okay, because then people will stop trusting the attorneys. Concept of attorney itself will cease to exist. Concept of will cease to exist. We won't need any more attorneys and any more wills will be written. And that's why it doesn't matter how much benefit will come out by execution of the will in later, okay, we need to uphold the spirit behind creation of will, that the person who is dying, his money will get disposed the way he wants. And that's why spirit behind any law or any provision or any constitution is more important than simply the letter of the law. Okay, because by following a letter of the law, still many illegal unconstitutional things can happen, and that's why spirit is more important. The essence is more important. So now we'll discuss this quickly in more detail. So what we mean by letter of the law? So when we'll follow letter of the law, okay, we hold strict adherence or obedience to literal interpretation of law. Okay, so interpretation, statutes and legal provisions based on their literal grammatical meaning. So following letter of the law means that strict adherence to the words, you obey the words or implement the words as it is. So strict obedience or literal interpretation of the law. The way words are, whatever their grammatical meaning, I will execute the law as per that. That's letter of the law. So interpreting statutes and legal provision based on their literal grammatical meaning means following the letter of the law. What spirit of the law, on contrary, says that one should adhere to the intent of the law. You don't follow the grammatical meaning, the literal interpretation. You try to understand why this law is made, what it wants to achieve, what is the end goal that law wants to achieve. Okay, what is the purpose with which law is created? What was the psyche, okay, of the constitution maker or lawmaker, okay, when they made this law? What debates that happened before framing of that law? So adherence to intent of the law. So why the law was enforced? Okay, why we enforced the law in the first place? Okay, why we created the law? What was the situation to address that we created the law? You need to understand that essence of the law, or focus on the broader context or the underlying purpose or essence of the lawmaking. So spirit of the law, okay, tries to focus on underlying purpose, the essence with which law is made, and tries to uphold that essence, that whatever the law intend to achieve, whether that goal is getting achieved or not. Because by implementing the law by grammatically in literal sense, okay, a lot of bad things can also happen. So what was the essence, the purpose, whether that purpose is getting served or not, that utility is getting achieved or not. So for example, in my district, Satara, when COVID was going on, okay, continuously we were following this lockdown norms or lockdown the particular area. Now almost 1 or 2 years has been passed and lot of lockdowns have been made, but no way lockdown was proving, okay, or was stopping this chain reaction of COVID. Patients were still getting infected. Everything was happening. All that was happening was due to lockdown. Largely, okay, economic activity was not happening. Economically, it was proving bad decision. Finally, people got frustrated and they decided to do civil disobedience movement, CDM, that we will pay the fine, but we are not following the lockdown guidelines. And so that's the issue, that you literally implement the lockdown, but without understanding the spirit essence that it should reduce the COVID cases. And if that is not happening, then you need to change the strategy. Okay, just because there is a provision available, you can't implement or take actions in a literal sense, okay, in grammatical sense. Okay, so lockdown ka purpose was to reduce the COVID cases. Lockdown ka purpose is not just COVID cases increase and ensure the lockdown. If it is not serving the purpose, the essence for which that thing was created, then you need to change, okay, that law even if needed. So spirit of the law focuses more on essence, the purpose, the underlying assumption. So one example of letter of the law or following letter of the law that I told you was lawyer defending the criminal client is following the letter of the law literally. While spirit of the law, the example of spirit of the law is a driver who is going 55 miles per hour on an empty road in a good weather condition may argue that they are not endangering anyone's safety and therefore not violating the spirit of the law. Okay, or any ambulance which is traveling with the and if in particular area speed limit is 50, but ambulance is going with 80 km per hour, or ambulance is not following the signals, it is breaking the law literally, but the decision or action of ambulance driver was to save a life. So he is more focused on, okay, the spirit in this sense. Okay, spirit of the law will be, okay, that I should not cause accidents or traffic should be orderly. But in that situation, okay, when he is driving the car, his essence or reason was to save a life. So he may not be following the law in literal sense. Okay, so that can also be one way you can interpret this debate. So letter of the law and spirit of the law. So spirit of the law, there should not be traffic accidents, etc. So I am the only person on the road. Okay, no one is there and I don't follow the traffic signal. It's a 1 a.m. at night. No one is there and I am the only person on the signal and I don't follow the signal because there is no other person and no disorder I will create by breaking the signal. Okay, so if I use this argument, indirectly I am hinting at the spirit of the law in this. So this situation is very problematic or debatable. Which one is better, which one is good or bad, letter of the law or spirit of the law. We can't directly generalize that. Okay, but let's see few more advantages of both and disadvantages both. So letter of the law, so it provides predictability and certainty. So when you follow letter of the law, it gives you predictability, it gives you certainty. Okay, that you have one constant law for all India. And lawmakers in parliament has created law, in Vidhan Sabha they created law. So all IS, IPS officer till down to the lowest bureaucracy, okay, that village secretary, okay, or tehsildar, deputy collector, etc., DYSPs, all those who implement the law will follow the law word by word and no one will interpret it different manner. And so it will provide some consistency to governance, consistency to administration. It will provide predictability, etc. And that's why letter of the law, following letter of the law is also good or necessary thing. Same way, letter of the law, people can have clear understanding of what is allowed, what is not allowed, what is prohibited, etc. So if you say that one should drive a car with the speed limit, with such a speed limit that he can control the car and there won't be road accidents, okay, and so any speed limit that you can control will be allowed on the road or highways. This will be very speculative. Every person will then start driving the car, okay, at his own speed, at his own will. And that's why you need clear-cut definitions. Sometimes literally clear-cut definition that 60 km/h, beyond that there will be fine, penalty. And so by letter of the law, we ensure predictability, consistency, clear-cut understanding, okay, objective interpretation becomes possible. There is no subjective interpretation of the law. हर कोई अपने मन से ओपिनियन के हिसाब से लॉ will not interpret the law. Okay, but if you go by spirit of the law, if everyone tries to make sense or spirit, then there will be a lot of subjective interpretation of the law. And largely morality then should be objectively interpreted, law should be objectively implemented. And so people can have clear understanding of what is allowed, what is prohibited if we have clear-cut, explicit, grammatically clear-cut language. Then spirit of the law में spirit of the law, why we need to follow spirit also? Because uske bhi advantages hai. That spirit of the law aims to achieve the underlying goals or intentions. If we follow spirit of the law, then ultimate goal, intention gets achieved. By letter of the law, many things will happen legally, but they will not achieve the end result, the end goal with which law is created. Okay, and so by spirit of the law, end goal becomes predictable. You achieve the end goal, you achieve the intentions of the lawmaker, okay, and final goal gets realized. So same way, so rather than narrow reading of the words, okay, we give a more comprehensive meaning to the letter of the law, and if we start interpreting it we go into spirit of the law. So if you go into spirit of the law, then we don't take narrow interpretation, literal interpretation, grammatical interpretation. We take a wide interpretation into account, and that helps in governance, that ensures good governance, etc. Then interpreting laws in the spirit allows for greater flexibility, enabling legal system to adapt to changing circumstances. Okay, so if we follow spirit of the law, then this allows scope, because situations are very complex, very dynamic, and that's why then if we follow spirit of the law, then rather law becomes more dynamic, laws become more flexible, your administration governance becomes more flexible, okay, and with flexible administration, flexible governance, you rather can govern in much better way, okay. And so interpreting laws in its spirit allows for this flexibility, okay, enables the legal system to adapt to the challenging circumstances, allow the legal system to evolve and meet the demand or meet the circumstances or deal with the different situations in a more effective manner. But if you go only by letter of the law, this flexibility is not there. Okay, letter of the law can provide you consistency and predictability and certainty, but not flexibility. Spirit of the law provides you flexibility. And so, letter of the law and spirit of the law. Now, what are the problems with the letter of the law and spirit of the law, both? So, first problem with letter of the law is that strict focus on the letter of the law can lead to rigidity, because there is no flexibility. I just now told you. Okay, it leads to inflexible laws. And problem is that situation, I told you, are extremely dynamic. Situations are extremely complex. And laws are static and general in nature. One law in parliament for all India, a general law, then automatically, okay, it is going to create a lot of problems. Okay, if you start implementing that law everywhere across the country, and especially in country like India, where there is so much of diversity in caste, class, language, har jagah se, we can't have a uniform legislations or one law, okay, implemented uniformly across all India for all religion, caste, in all conditions. It will prove good, okay, but in many situations it can prove to be very bad. And that's why if you go literally by the law, it can ensure it causes rigidity. Situations are extremely dynamic, complex, and your laws are static and general in nature. And if you don't bridge this gap between general static laws and dynamic situation, complex situation, then governance becomes very inflexible, rigid, and it can, instead of ensuring welfare state, good governance, actually it can even create more pain. And that's why, okay, this major problem with letter of the law is that, okay, if you literally follow the law, then situations which are dynamic and complex, okay, and laws which are general and static, okay, it will create a lot of problem. And so we need to understand, if we understand spirit of the law, then by understanding spirit of the law, we can take situation into account. In that particular situation, if this law will achieve the intended goal, essence, spirit or not, that will get decided, and that is more important. So relying on the spirit of the law introduces subjectivity into legal interpretation. Okay, so if you follow the spirit of the law, okay, it introduces the subjectivity. But problem kya hai fir? Letter of the law, I told you, letter of the law will make governance very rigid, inflexible. Okay, situation are very dynamic, and letter of the law is a static situation, that this is the law and implement as it is. Okay, law becomes very static, general, situations are dynamic. But if you go by spirit of the law, then other problem gets created. If everyone start to interpret law in his own sense, try to understand the spirit, essence, makes his own interpretation, then legal process will become extremely subjective. Okay, and we need not subjective interpretation, we need a objective interpretation of the law. So relying on spirit of the law introduces subjectivity into legal interpretation. Okay, and this leading to, and which will create a lot of uncertainty and potential abuse. Every collector starts interpreting law in his own way. Okay, every deputy collector, DYSP, tehsildar, village secretary, they start interpreting the law, tries to make their own understanding of the law instead of following the law or order as it is. Then obviously it will create a lot of problematic situation. And that's why this uncertainty will prevail. Subjectivity in process will increase, and largely we need objective law. We need to keep opinion outside, biases outside. Okay, so एक चंद्रचूड़ हमारे जो सीजे है उनका एक काफी awesome statement है. Okay, that I try to judge without being judgmental. बहुत classic statement है. I try to judge without being judgmental means I try to ensure that my opinion, my biases, okay, my viewpoint, this remain out of my decision making. And while giving a decision, I give a very objective decision. And so this objective decision making is a very, very important thing in legal process. We need to keep our opinion, biases, etc. outside. Okay, every bureaucrat, IAS or judge comes up with his own personal biases, stereotype, prejudices, whims, opinions, and they have to be kept out. And largely we need to implement, okay, the law in literal sense. And that's why this, if you go by letter of the law, objectivity will increase, but that will create a problem. Okay, because situations are very dynamic, complex, and such an objective static law will not be good to govern in the situations. And if you go more by spirit of the law, it will increase subjectivity and it will create a then unwanted problems. Okay, there won't be any certainty in the lawmaking. Different individual or entities may have varying interpretation, and governance will become extremely problematic. Okay, it will lose objectivity, and governance will become extremely subjective thing. So both letter of the law, spirit of the law has its own pros, has its own cons. So then how to conclude that? How you will settle this debate? Only one way that you and there are people with good conscience, viveka buddhi, in that position who will use this discretionary power in a good manner. Then these people, okay, will be able to understand letter of the law, spirit of the law, and will take a decision as and when required by letter of the law or as and when required by the spirit of the law. Okay, so effectively applying the law requires balance between the letter of the law and the spirit of the law. Okay, you need to know this is not like black and white situation. The letter of the law is better or spirit of the law is better. A lot of gray area is between, and we need to achieve the balance between letter and spirit to ensure good governance. Okay, so striking the right balance is essential to ensure both predictability. That right balance, why you need? Because you need predictability in governance. You can have subjective governance all time, everyone interpreting law in his own way. You need to ensure consistency and predictability, but at the same time you have to ensure this consistency, predictability, implementing law in letter will not lead to injustice, will not lead to unfair practices or bad governance. So you have to ensure this good governance, fairness, as well as you have to ensure predictability and objectivity, and striking the right balance between both predictability and fairness, justice, is very much required in legal system, in administration. And so for that, first thing you need to do is that discretionary power, that's why becomes very significant. You need to implement discretionary power. Discretionary power becomes very significant. So judges play a crucial role in interpreting and applying the law. Okay, but discretion can be a double-edged sword. Okay, so significance, why it is more important? So significance of discretionary power. So judges play crucial role in this process, because I told you have law, general one law of parliament which can be implemented across India, and we can't even create thousands of law satisfying every situation. So obviously we need a general law, but at some point that law should stop, and beyond that, when situation become very complex, dynamic, etc., then power should be given to that local authority. Discretion should be given to that local authority to take a decision as per his own understanding of the situation complexity, backed by the law. So what I mean by that, when COVID was there, India में बैठ के Delhi में Prime Minister locked down the entire country. When there was no patients in Northeast, still India was locked down. Only patients were in Kerala, Karnataka, Maharashtra. Rest of the India locked down. And when patients started to increase across India, we removed the lockdown. Uske baad bhi lockdown was coming, going, all these situations are happening. Situation wasn't improving. So what we did, we devolved power or decision making. Instead of making law for entire India lockdown, we devolved the power to the lowest level, to the level of IAS officers. Even later on, power was given to deputy collectors, tehsildars, कि आपके एरिया में as per the situation you decide whether there should be lockdown or not. Okay, so we need to give discretionary power, we need to use discretionary powers. Okay, and judges play crucial role in interpreting and applying this law. Judges ho ya administrator ho, anyone who is implementing the law need to be given little bit discretionary power, so he can govern using this discretion in much better matter. But here I have written that discretion can be, okay, discretion can be double-edged sword. But guys, when we give discretion power, then it has lot of problems also. It creates lot of problems because discretionary power has many negative impacts also. Discretionary power can lead to a lot of misuse of power, abuse of power, even breeds corruption, etc. If people governing or on spot who is acting, if he is not ethical, moral person, then he can misuse discretionary power. So discretionary power is also called as necessary evil. So in ethics paper, you will directly get question. Discretionary power is necessary evil, comment, explain. Or discretionary power is a double-edged sword, explain. So in my app classes that I am launching on my Darshanik IS app, so on my app classes, there will be this discretionary in ethics lecture, one debate. Okay, I will take only on the topic of discretionary power. Many such unique topics, okay, that I will discuss, like discretionary power, in detail, advantages, disadvantages, why we need to give it, why it is necessary evil, what are the problems, and how to control or keep check on discretionary power. So entire that is totally separate topic. Same way, there are terms like conflict of interest, how to deal with that, okay, how it arises and how we can resolve it, etc. So all this concept we will be discussing separately. So there on my app classes, I will be discussing this concept of discretionary power separately. But here, if we want to deal or achieve balance between letter of the law and spirit of the law, you need a discretionary power. Okay, it is a necessary evil. Secondly, you need to ensure dynamism in legal system. Okay, your legal system should be very dynamic. Now UPSC कुछ साल पहले asked essay on a topic that this 21st century India is governed by the or colonial mentalities hindering India's success. ये एक लॉ था, ऐसे था, या एक ऐसे ऐसा भी बनता है कि 21st century India is governed by 20th century bureaucracy with 19th century laws जो 1860-61 में IPC CRPC बनाया. So if we make a law एक ही बार उस situation में and implementing that law after 50 years, we are using the same law, then automatically the letter of the law and spirit of the law will create a lot of problem. Today we have made a law considering the today's situation with some spirit, some purpose to achieve. और अब 50 साल बाद we are still using the same law. 20 साल बाद when situation has totally changed, okay, then automatically we need to change our laws. Else after 20 years, if we still follow that law by later, then its spirit will totally get destroyed. Rather, it will create more problems. And that's why if you want to keep achieving the right balance between letter and spirit, then your laws should always or very quickly, you need to keep updating the laws, okay, keep modifying the laws. And that's why, okay, dynamism in legal system, that legal system need to evolve, and statutes that are outdated must be modernized to better align with the contemporary values. Your legal system should keep updating, okay. There should be a lot of R&D should happen in legal system, and continuously laws should be evaluated, interpreted, people's feedback should be taken, and we need to keep updating our laws with the time. Okay, there should be extreme dynamism in the legal system, and if we can ensure this dynamism, okay, and update the laws with the time, then we will be able to keep gap between letter and spirit of the law. We can narrow that gap, okay, and letter of the law and spirit of the law will match, and there will be better governance. Okay, so that's all about this small topic. It's very significant, important topic. That's why I wanted to discuss with you. Okay, so stay tuned to my Darshanik IS YouTube channel. Okay, share with your friends also, and join me on UPSC Ethics Telegram channel to download these notes there and to remain updated. And then you can download my app Darshanik by Kadam sir from Google Play App Store. And then I will be launching by the end of this December month full-fledged ethics class course there, and soon essay course will also follow. So stay tuned there for those classes. So thanks for listening, and stay tuned to the next class.